I'm Flavia Berlieni Zimmerman from the Australian Institute of International Affairs in Western Australia. And today we have with us Dr. Erica Teixeira, Professor of Law at the University of Western Australia. And today we are going to discuss space law, good governance, and advancing Australia's space strategy. Thank you for being with us, Professor Teixeira.
Thank you very much, Flavia. It's a pleasure to be here.
In your opinion, what are the main innovations globally and in Australia when dealing with space law?
Well, I think when we talk about space law, we need to think about sort of the history and the evolution of space law. So we've seen quite a lot of national law now in the last few years, and Australia has recently updated its national legislation in line with the Civil Space Strategy to meet the needs of Australia's priorities. So our new act is about launches and returns of space objects and high altitude rockets, for example. So what we're seeing is those national laws being developed, but they're also built upon and still will depend upon to a certain extent the principles that are founded in some of the older space treaties that were adopted back in the 60s and 70s. But what we're likely to see in the next few years, I think, is more developments as different countries who may not have had a space agency or a space program in the past, as they start to adopt policies, adopt strategies, develop institutions at their national level, and then they start to pursue their national priorities.
Thank you very much. And when we are dealing with international law, in your opinion, international law, what role it plays in space activities globally and in Australia?
So there are 5 space treaties. These are binding international treaties, and the most significant one of those is the Outer Space Treaty. And sometimes that's described as a constitution for space because it sets some basic principles that all the nations that have ratified that treaty have adopted. And so they include one of the key matters, which is we're not to militarize space. Space is to be used for peaceful purposes. It's not to be appropriated, can't be acquired. Countries can't adopt sovereign territory in space. And so those principles in the Outer Space Treaty still provide a firm foundation for the development of new international law, bilateral arrangements, but also national arrangements. We have 3 other treaties on rescue and liability for accidents, as well as registration of space objects. Those 3 treaties are still very relevant today, even though they were developed many years ago, before we envisaged the kind of space activities we're seeing today. The last space treaty is the Moon Agreement, and that's more controversial because it is only being ratified by a handful of countries, 11 countries. And it's controversial largely because it extends what the Outer Space Treaty says on non-appropriation. And it says that any exploitation of resources on the moon should be shared amongst nations. So it's very similar in its wording there to the deep sea bed under the high seas, where also we share the benefits amongst different nations. And obviously that's not attracted the same amount of signatures as the other treaties because of that provision. But Australia is one of the countries that's ratified it. So that international law, that binding law, still plays an important role. We also have some resolutions of the UN Committee on Peaceful Uses of Outer Space, which is the main UN body that develops new law, has a legal subcommittee. And they are still developing law, and they have continually developed law. Some of that is global soft law, and one of the soft law documents that we're most familiar with, perhaps, is the Space Debris Mitigation Guidelines. So they're not legally binding, but they set a common framework to try and prevent the creation of more space junk, more debris in space. And so that's still very influential because when you go all the way down through the Australian legislation, you look at our Launches and Returns Act, you look at the regulations under our Act, to get a launch permit, you do need to have a strategy for space debris mitigation, and that strategy must be developed in accordance with an international standard. And that standard is often the space debris mitigation guidelines developed by UN COPUOS and the IADC. So you can see that influence of that law still today. And of course, there is plenty of potential for the international community to develop more treaties and more binding law in the future if they wanted to.
Thank you very much. And when we are dealing with the limitations of international law, and you are mentioning that particular treaties, not many countries have ratified it. So, how can we mitigate those limitations of international law and also encourage some countries to ratify particular treaties? Are there any strategies we could develop?
Well, I think we have to either develop and kind of sell the objects of the Moon Agreement to other nations. I think that would be quite difficult because benefit sharing of the resources on the Moon is unlikely to attract all that much attention. So it may be that we need to develop new law. It may be that we need a different agreement. And certainly we need to keep discussions going forward, because the last thing we would want is a free-for-all of activity on the Moon. So the strategy, I think, partly is to keep states engaged in the conversation, to ensure that there is a platform for negotiation of new instruments or even soft law initiatives, and to make sure that nations that might be considering becoming spacefaring in the future or looking at commercialization of resources on asteroids or the Moon, that they are also engaged, not just the existing space active nations.
Thank you very much. And can you please explain the main goals of the Australian Space Agency with the Australian Civil Space Strategy for 2019 to 2028?
Well, the Civil Space Strategy and the Australian Space Agency, they're engaged in taking advantage of the capability within Australia, building a space sector, a civil space sector. It's not to do with military or defence capabilities, and to make sure we're regulating, we're contributing to the international community in terms of our regulation, but we're also engaging more broadly with the kind of international discussions and negotiations we've been talking about. So it's about preparing Australia to be a very active participant in the space sector now and into the future.
Mm-hmm. Excellent. And when we're dealing with governance and legal terms, what can Australia do to increase its space strategy? What are the goals and which strategies, in practical terms, when you think about governance and the legality of this new emerging field of space activity? What can Australia do?
Well, obviously, Australia, to meet the goals of its space strategy, needs to develop its capability, needs to keep investing in education, in technologies, in development, and then also keep developing the law and to make sure that it's done safely, and to build that future workforce that we'll need, which will largely involve people with very different skills than we already have. Australia also wants to keep the doors open to international negotiations, make sure we're partnering with other international agencies around the world, and to find a mutually supportive or mutually beneficial projects we can become involved in. So in order to meet that strategy, obviously we have to do a whole range of things involving all different types of disciplines. But from a regulatory point of view, I mean, Australia committed to updating its legislation, which it has done already. It now needs to, and it's developed detailed regulations for launches and returns. We're now developing launch capability ourselves, and that will bring with it a whole range of other legal, regulatory, and practical challenges. But I think that as part of that, if I could just step up and talk about part of that international community, I think there are a few areas where we, as a member state, need to really think about new developments that we might need. So we're starting to see tourism being a very real possibility now. We don't have detailed binding global regulations for space tourism. We might need to think about that. America, for example, has some national law in that department, but we really need to think about globally and contributing to a global discussion about tourism. We need to think about commercialization, and there's now more and more discussion and interest in the commercialization and exploitation of natural resources. We need to think about those frameworks. If it's not going to be the Moon Agreement, then what kind of global framework do we need? And if we're not going to have a global framework, should we have a model law so to make sure that we are not fragmenting our legislation so that each country has different laws? It's much simpler to have harmonised laws. It makes processes simpler when you've got companies that could be multinational, or you could have a company that's registered in or incorporated in one country is then launching objects in another country, landing them in another one. We need to try and harmonise that law if we can. There are developments by the International Law Association for a model law in this area, and there are other developments. And I think really the third area is probably space debris. That's increasing, not just space debris, in fact, but the congestion in the low Earth orbit in particular, where we're seeing these cluster satellites being launched, and what kind of regulatory framework do we need to put in place? We have the soft law guidelines at the international level, but are they sufficient? And are they going to protect us to protect in the sense of being able to create an environment where there are orbital slots left where it's safe to launch objects? You're not going to hit space debris. How do we manage that congestion, which is increasing very, very rapidly now as launches become cheaper, as satellites become easier for people or corporations to launch. So I think probably they're the three areas where we're going to see some developments. Whether they will be at the global level, whether they'll be at the national or the subnational, regional level, I don't know. But there are many examples to draw from. We can draw from some of the examples of laws back on Earth, some of them the high seas or Antarctica or other places where we've had to deal with some of these challenges. But in other respects, I expect that many of these laws will be brand new because this is a new legal frontier the way it is a new technological frontier.
Fascinating. And wrapping up our interview, if we are dealing with new laws which will be enacted to deal with space law, I think it's important that we have great transparency on these processes. So my question is, how can we foment more public debate regarding the processes for new legislation regulating space law, and as well the new governance that is going to be set in place?
When taking Australia as an example, when we adopt a new law here, we have periods of public consultation. We have a time during which industry, members of the public, NGOs can all make submissions, and those are read by government and taken into account before the law is finally drafted. And through that process, I think we can engage very actively with the private sector. And that's obviously a very growing sector, and not just satellite companies that might build satellites or launch them, but also companies that might finance them or insure them, because they're all stakeholders. So we need to have a very broad stakeholder conversation. That's for national legislation. It becomes, I think, a little bit more tricky at the international level because treaties are signed by countries, not usually by private actors. But something I said before about this development of soft law or more of a policy non-binding approach, that can involve private actors and industry much more effectively than a treaty, and you can get soft law that is signed up to by private actors as well as countries. It can be open to a much broader group of people. The other way I think, if you have a look at some of the developments at the moment, is there are increasingly a number of organisations with individual different mandates that have emerged and have started to gather some momentum. So if you look at the Moon Village Association, that's just one example. There's different organisations like that which are civil society based, and they are creating a platform for discussion as well. So we need to be across all of those different areas, I think.
Thank you so much, Professor Teixeira, fascinating talking to you. And for more information, please visit our website, www.internationalaffairs.org.au. Thank you.
Thank you.